Hello and welcome to That Fine Bachelor's Law, a podcast. In today's episode, I want us to talk about bail. Oftentimes, we ask ourselves, how do violent criminals find themselves back in the streets after they have been released? Today, I have a very special guest for you. He was, in his other life, a prosecutor of note. Today, he has skipped on the other side of the conversation. Rangakagai, welcome to the podcast.
Ke a leboga morwarre, ke a leboga.
Yeah. Gongwe ha re simolola hela o ka ipolela batswana gore o mang.
Ke a leboga batswana betso, ke bidiwa Kgositsile. Ngaka I'm a legal practitioner. Presently, I'm operating under the name and style Ngaka and Company. Previously, as he indicated, I was a prosecutor.
Yeah.
So essentially, I have been both sides of the divide for nearly 25 years now.
I think that is why I chose to bring you for this conversation.
Ke a
Ka gore o tlhaloganya mathakoro otlhe a kgang e ya morututhai e leng gore re bua ka yone e leng gore ke kgang ya bail. Go a re simololle puisano ya rona. When you look at the constitution ya Botswana, go section 5, e bua ka the right to liberty. Go re ka simolla ra tlhantlhamolla yone tsetlane eo ya molao motheo gore mme yone e raya eng mo mothong.
Ke a leboga. The right to liberty proceeds from the philosophical understanding ya gore we are all born free.
Yes.
Gore, in terms of legal philosophical thinking, but halihi ba molao ha ba akanya ba simolla mo goreng motho setho was born free. Le gore we have only surrendered some of our freedoms for the collective good.
Yes.
That is why re na le the right to liberty.
Yes.
That is why go sena the right to take away liberty.
Yes.
Ha go no na le right to take away liberty, me batho ba na le right to liberty. So the right to liberty is the foundational premise.
Yes.
I would say after the right to life.
Yes.
In my order, gare the right to life, ha go tswa the right to life, go tswa the right to liberty, because without the right to liberty, you can't enjoy any other freedom.
Yes.
Hotelele.
Basically, se re siwang ke gore mongwe le mongwe ha tsholwa o na le tshwanelo gore a gololesege gore o kaya kwa go batang a seka a tshwarwa kope or to be imprisoned, so to speak.
You are entitled to your freedom to move about freely, to pursue happiness your own way, without anyone about the limitation. Mo kgolesegong ya gago
Yes.
ya go nna free.
Yes.
So it's one of those very, very fundamental rights that you enjoy, without which you can't enjoy the other rights.
Mme kana ha re lebella one molao motheo ha re bua ka seesemane ra re that right is not absolute. Go na le ha e leng gore kana go na le mabaka ha re ntse re tsweletse ka puo ya rona ka puisano ya rona re tla tsena teng. Go na le ha e leng gore molao o ka ira gore that liberty ka e ka fokodiwa. Mme ke batla re puisano ya rona re amanya gape le section 10 1 ya one molao motheo. Go re simolle ka go tlhantlhamolla yone section 10 gore yone ya reng e go neela ditshwanelo dife o le Motswana.
Let's start it right here.
Yes.
Go ntse yalo, go na le gone gore your right to liberty e ka ne e ngotiwa kana e hukodiwa go gongwe. That is true. But go hokediwa ga tshwanelo eo ya gago e tshwanetse go nna hela mo e leng gore one molao motheo o hand the right to liberty e go authorize-itse
Yes.
yo reng ke tsaya sengwe from your right to liberty o tshwanetse gore a re ke se tsaya ka gore molao motheo o mphile dithata tsa gore ke se tseye mo mabakeng a re berekelang mo go onea. So the right to liberty is sole limitation. Ke limitation e hela e leng gore it's according to the Constitution, not according to any man. No man can limit your right to liberty or has power to limit your right to liberty.
Yes.
Only the Constitution can allow a man to limit your right to liberty. So negatively Montaigne it's not absolute, it's accurate. But the only limitation is constitutionally authorized fair.
Go ngara e be mo tafoleng yone that limitation gore limitation ya yone eo e re itlhela mo molao motheong ke efe?
Molao motheo is fairly broad because se molao motheo se buang yare such limitations fela as would be permissible in a democratic society. Idirisa le hoko democratic society. A democratic society is a society based on the rule of
Law.
on the rule of law. And only on the rule of law. Maybe le gape the limitation eo must be absolutely necessary for the constitutional purpose e setsweng morago. For example, ha e le gore o limitelwa gore o seka wa go utusa motho bothoko. Limitation eo e itebagantse le gone mo hela. When that threat to another person has been taken care of, you are supposed to be restored your right to
liberty or whatever.
To
right.
liberty.
Yes.
You know what I mean?
Yes.
Hey, so the right to liberty itebagantse le the specific limitation that is in issue at that point, except only in instances where now as a consequence of a court judgment, where a court could potentially say, re go isa matamong for 10 years.
Yes.
You see what I mean?
Yes.
There is punishment.
Yes.
You are not go limitelwe hela gore o ska go isa ba bangwe bothoko. Ho bo ngwe wa bo o thaiwa. Which is another thing. It's still a right, but it's all constitutionally authorized.
So it falls within that caveat. They are acceptable within a democratic
society. Yeah,
which is
such
based on the
limitations,
base of law.
Yeah, which is purely based on the rule of law.
Yes.
And such rights, the rule of law is based on this three-tier system. Obviously, the court is the ultimate arbiter of right and wrong between the citizen and the state or the executive.
Yes. I think there, now let's segue to section 10, subsection 1 of the Constitution, where now we speak of someone being innocent until proven guilty in a court of law. Ka gore kwa tla ha re ntse re tswalla ka puisano ya rona re be re irile one moalo for bareetsi ba rona gore ba tlhaloganye.
Yeah, I think we ought to proceed on a clear understanding of that provision.
Yes.
The provision speaks to the presumption of innocence. It's a presumption. It's not a fact of innocence.
Yes.
So oftentimes people will be like, I'm innocent until proven guilty. It's a misstatement.
Yes.
I am presumed innocent until proven
Guilt.
guilty. You could be guilty, just that that state has not been judicially determined.
Yes.
So the only authority that's going to say ultimately that this person is guilty or is innocent is the court. But we haven't entered that inquiry yet.
Yes.
That's why it's just a presumption. So, go mo maikarabelong a puso yone e le gore e latogatsa batho gore be re ra re motho yo ga a innocent ka mabaka a le a le a le a. By so doing, puso e lwa le this presumption, is chipping at this presumption, is trying to change the color of water
Yes.
up to a point where a court can now say, look here, you were presumed innocent, but we have since found that you are in fact guilty. The presumption of innocence is key to any just legal system. Let's put it conversely.
Yes.
Already the presumption was one of guilt. You are presumed guilty until proven
Innocent.
innocent. What that would mean is the burden would be on you. Horo wena, ene wena, house na go tshwarwa. O convince ang khote ano gore o tshwaretswe. Me se wena o itisitseng ko kae?
Go kgotlatshekelo.
E se wena o itisitseng ko kgotlatshekelo. Now, historically speaking, that was the scenario. Ne go sena tsamaiso ya presumption of innocence. Motho o na te wa la go te o ithetswe ka so se ikgolole. Motho a ba tlhoka tsone di tools tsa go ikgolola, a ba solwa mo toronkong ba bangwe ba bolaiwa ba bangwe. And over time, e be go na le this understanding, golo mo ga go tsamaye sente. Let he that alleges be the one to prove. Puso ke yone e reng motho yo o molato.
Yes.
A marudi a nne mo pusong gore e tlhalose gore ke eng e re motho yo o molato. Ha e le gore puso e ta e supa motho ka monwana e re o molato mme se na bosupi jo bo lekaneng. Go ra gore motho yo a tlogelwa a tsamaye. Because ene yo mo supang ka monwana e leng puso ga a tla ka bosupi jo e le go botsantse gore bo mo reng bo mo isa toronkong kampo a bo tlhaelo kana a bo bonwe molato. So the presumption of innocence is meant, among others, to restrain the state, not to interfere with liberty. It is written against the state. To say, state, if you can't prove his guilt, leave him or her alone. As they say, it is better for 99 guilty people to walk the street than for one innocent person
To be killed.
to be killed or to suffer punishment for a crime he did not do. So this is the basic protection to restrain the hand of the state.
Thank you. Ke tsela gore we adile ka botswerere. Re tla go kgwa setshwe ha re tswa gone kwa jaanong re tla be re tsena mo moding wa kgang ya tsatsi eno e leng yone kgang ya bail. We'll go for a short break. When we come back re tla be re tsweledisa puisano ya rona le renga ka gae re bua jaanong re tlhantlhamolla yone kgang ya bail gore mo molang wa rona e tsamayang e tswa ko kae mo go one motsotso molao wa rona o ha kae. Thank you. Welcome back to the show. I'm still with Rengaka Khaye here. Re bua ka yone kgang ya bail. Rengaka Khaye. Bail ke
Bailey ke thata ga ke batla gore ke re ke tshwanelo because puso ga ena tshwanelo against an individual's liberty.
Yes.
Bail ke thata e le gore molao motheo o e neela puso gore mo mabakeng mangwe a rileng a kgethegileng e ka re le mororo motho a ise a bonwe molato puso e be e ka re kopa gore a name a tshegeditswe lebaka go le gantsi e le gore go na le mabaka mangwe a e leng gore ha a lebellwa a beilwe leitho a dira gore go nne le kakanyo ya gore golo gongwe ha re ka re emela gore motho yo a seke pele re ka nna ra ithela re tlhagiseditse setšhaba kotsi ka tsela nngwe ga e re motho yo o guilty ya re mme hela go na le mabaka mengwe a kgethegileng a e leng gore ga re a sekaseko mo molaong wa itse re na le seinye reng to every general rule there is an exception.
Yes.
Nothing is absolute. To every general rule there is an exception. The presumption of innocence ntse e emegela jalo le mororo motho a tsetswe kgololesego eo ka nakwana ka mabaka a e leng gore a bo a le teng ka nako eo a bong e re mmaka strata a lebella a ba ka re meha let's work with the exception re name re mo amogile kgololesego ya gagwe re emetse e seng gore re emetse tsheko because o kgona go e amogwa e se go emela tsheko mongwe o e amogelwa hela gore ka nako eo go tshabiwa gore o tloga o interfere le basupi ha fie eo e tsamaya le tsheko ntse ile ko pele o a releasiwa mo bail.
Yes.
O bona kera so ga se no e amogetswe okay it's called bail pending trial because it's before the trial.
Yes.
But mabaka a e leng gore go le gantsi bail e tsewa ka one a mangwe a very temporary in nature rather temporary in nature.
Yes.
Ebile are very situational. Once the situation e leng gore is being addressed e sa thole e le teng then o kgona go boa o tla re ke kopa bail. That's why mo molaong re bail is ambulatory. How the bail is ambulatory go tewa gote so long as o le pele ga lone le khota leo le le gore o emetse tsheko gore e tsene ha pele ga lone le ha ile gore bail ya teng e gannwe maabane hela ha mabaka a change o kgona go nna o ntse o ta o applyela bail gore principle e re twa re bua ya go teng factor sofiki yo mo molao ya gore a le khota le tsere tshwetso gangwe hela go heletse ka wena unless o appeal go baileng ga e bereke bail is ambulatory hela go nna le any change in circumstances o kgona gore o reng o apply le bail ha ngwa police ba re no a re name re mo keepile because go toga go produce investigations are continuing ka moso investigating officer wa ta go khota re investigation di heletse o apply la bail go no a ke le baka le no le betswe e ne le gore go santse go investigatiwa ya no go hedile o apply la bail immediately. So bail is only denied in the interest of justice. It is not denied to appease the public.
Gone go intisa gore gona le selelo kana go ntse fo dingwaga go ntse gona le selelo gore dilalome tse leng gore di keteka batho tse dingwe di bola batho tse dingwe di amoga batho di tsa bone ikete yaanong ha ba ya ha pele ga makgotla tshekelo ba tswa hela sesolo ka mosong go te motho o tsetse o mongwe botshelo mme morago ga malatsi a le mararo mona gape a gwanta mo strateng a kwa re leke go atolosa one mabaka a leng gore lekgotla la sekaseka kana bogologolo gale le ne le a sekaseka gore go ne go lebiwa eng ha motho a ta neelwa beile.
Thank you. Kanya bail is a maelana thata le kanya presumption of innocence. Because if you are presumed innocent, because you are presumed. Because you are presumed. If you were to presume someone innocent and then deny them bail, then you are presuming them guilty, practically speaking. But
yes.
Homing in straight, like onto your point.
Yes.
There's one principal reason. There could be other reasons, but there's one principal reason. Bail is intended to secure the attendance of the suspect. Ka nako ya eng ya tsheko. Gore motho yo a kgone gore ka nako ya tsheko a ba a le teng go arabela molato wa gagwe, because in the meantime o presume you are innocent, we can only restrain or curtail the liberties tsa gagwe go tswa ga go ema hale. Now kgang ke gore ha le khota le balare a mme yo ngaka gae ke ra e be le malala pipe yana e le gore mapodisi before ba motsaga ba motisa kwano ba gile ba tsamaya botswana yo the ba mmata ba sa mmone a mme tsatsi le re beile ntsheko gore e tsena ka lone a eta re letla a re tla mmona gone ha a tsile go arabela molato wa o lebisitsweng. Ha ka le khota le ba lo be le re mme mabaka a teng a supang gore motho o ka nna se ka boela go tla go seka tsheko ya gago, le khota la gore a re motimeng bail. Ke lone le baka le golo behind bail, to secure the attendance of a suspect for trial. Mme go na le mabakanyana a mangwe ko thoko a ile gore lone a lebelelwa ha se le o hela. Lebaka le lengwe khona gore gongwe enne ke ha se kae e khona go nna gore mme ha re ka mogolla ba gaetso ntehela ga gore he could be a flight risk. A motho yo o ka ske re lebile boitsholo ja gagwe le boitshwaro ja gagwe ka ha itsang ka teng a o ka ske a tlhagisetsa setšhaba kotsi. Could he somehow be a threat to the public?
Yes.
Ha ngwa go lebiwa go ithela le gore ke di previous conviction he la gore o matlola a di dira, you have confirmed cases tsa violence tsa mo ile gore a go lebiwa ga te yo a ba boleile ana ka nna ra bo a ba reng a ba bola gape, because o setsa a kila heta mothala ga go ke wa bona. Ha gongwe go lebelelwa gore mme motho yo a ona le tshono ya go interfere le basupi ka gore ditlhotlhomiso di a bo di tsweletse. Yo mongwe is a bully ke se ganka hela ha tswa ho o tla ba tsamaya masigo a tsamaya tshosetsa batho ka dilepele melamo gore wena hela ha o ka kgabola go le khoteng o ta ha bosupi kgatano le nna ga mmago ke nage o bona kera. So go na le mabaka ao ga se one hela a mantsi a ile gore a lebelelwa go lebelelwa gape gore do you really have a fixed place of abode go ka bonwang teng. Mo gongwe you are a foreigner.
Yes.
Kuro no tsile hela kwano gongwe bonna mo ba re ngwana gore o sentse mme a go lebelelwa ga gona le haele sepe se ile gore ka re ka moso ga te o se boela mo botswa wa bona go lebelelwa mabaka ka bontsi gore a mme motho yo ke yo ile gore tla re ka moso a gone go boela gape ko lekgoteng. So all those considerations are looked into, including the fact ya gore mme kana motho o le ha re bua dio tsetso theka ene yana boammaaruri ke gore he is presumed innocent. So all these factors are seen through the prism of the presumption of innocence. All these factors have to be counterbalanced or counterweighed against the presumption of innocence. Di ka tswa di le teng mme go bohelong le khotla be le re no mme le ha gone go na le gore o ka nna se ka boa ha re ka tsenya appropriate bail conditions di ka hokotsa risk ya gore o ka se ka boa. Ha re ka tsenya appropriate bail conditions di ka hokotsa risk ya gore o ka interfere le di-witness. Ha re ka tsenya appropriate bail conditions di ka hokotsa risky ya gore o ka nna a threat to public safety. For example, go limita di-movement tsa gago. For example, go limita communication ya gago le ba ba amegileng mo molatong. For example, go mo tseela dipasa. For example, go mo restricta in any way go iletsa sone se ile gore re tshaba gore ha ka hiwa beile ka go se dira.
Ha ke go utlwa sente gore ha motho a neelwa bail go na le ditsetlana dingwe kana conditions that are put in place to ensure jaaka no tlhalosa gore motho wa iponatsa ko le kgotlatshekelo. Di-condition tseo ha di bewa ga bo go lebilweng ke botsa yana ka gore go na le selelo se leng gore gantsi re tebe re utlwa and go common thata le wena o ka ntshupela gore mo makgotleng a rona go tswe gote motho o neetswe bail go gote the bail amount has been set to 500 kana 1000 nako ya teng gongwe molato e le polao ya motho e leng gore o latofadiwa ka gote o tsetse motho botshelo mo maranyaneng mo bate ba kwala ba re that bail amount is laughable and ba ba di nang kola di le dintsi gongwe o ka latlhela le thware kera thware le gonyana ho
ntse yana morwadi tota o bona maranyane one and I see this with the greatest humility and respect. Maranyane ke maakaela maranyane ke maakaela morwadi re go maranyaneng ke maokaneng mongwe le mongwe o bua maikutlo a gago hela kore whether o na le o kilo a akanyetsa subject e kana o kilo iphana kwa go bala go checka gore gate seemo keng go maranyaneng hela gompieno yana hela go te shatho o rile kore go maranyaneng ga go bereke ya go molao go maranyaneng ke presumption of guilt
until
in the courts of social media there's a presumption of guilt.
Yes.
That's why legal practitioners like us will never be at peace. Le commentators mo maranyane, because you are working from two opposite ends. Otlaka a training ya presumption of innocence, but laka ya bonea presumption of guilt, and that's where honang hotola di thasite. Like they would say, okay, look. And you are right. They'll be like, 1,000 pula. This is laughable.
Yes.
Why is it hubua man? Hubua ngaka yo noang 1,000 pula yo. Ko bari in an hour. Kana moja ko kapil. How mo thunyola to haditsweng yo 1,000 pula o ke madi a eleng gore ga ana le haele one. So when you say this figure is laughable, it's laughable to you on account of your socio-economic standing. To another person, that 1,000 pula is a salary.
True.
So it's all relative. But in the courts of public opinion and the courts of social media, those factors ga di lebelelwe. Go lebelelwa hela re hating ha to boleile motho o bona re se re motho ka gore boleile motho.
Yes.
Because re se re conclude le gore boleile motho e bile a gona le baka la gore ba boleile motho go tleng go tleng. Ra re botshelo ja motho kgathanong le 1,000 pula ke re compare di completely tse ile gore ga di
Apples and oranges.
Apples and oranges.
Yes.
Woman, apples and oranges. And remember, there's a presumption of innocence.
Yes.
So you can't have the Constitution give someone that presumption of innocence. And then innocence yo gape be re kwa ka madi a go godimo.
Yes.
O bona ke rang?
Yes.
O bo tshwana go re o redime liberty e leng gore we neelwa as a constitutional right by paying a hefty sum which makes nonsense of the constitutional entitlement or right in the first place.
Yes.
Sure.
Ka bokhutshwane hela, whatever conditions tse di attach you to you being released on bail, ga di a tshwanna gore di nne prohibitive, ga di a tshwanna go go kganela gore kgololesego eo e leng gore molao motheo wa go ena o ka palelwa ke go e bona.
The conditions must serve only one purpose.
Okay.
Protect society, ensure that you are there at a time when you are needed for trial. The conditions are not meant to placate the public. Public. The conditions should not be punitive. They are utilitarian in nature. They serve a specific constitutional purpose.
Are khame gone ha ro ra go khwasetswe ha re tswa kwa re tla tsa re kano ka molao o mošwa o e leng gore parlamente ya o hitisa o buang ka bail. Let's go for a short break. When we come back, we'll deal with the new Bail Act and what it means going forward mo dikganyeng tsa rona tsa semolao ha re lebile criminal law. Thank you. Welcome back to the show. We continue our conversation le renga ka gae re bua ka khanya bail. Renga ka gae. Parliament towards the end of last year passed an act in Parliament, which is the Bail Act. King se se neng se gwetlha Parliament gore e hitise molao ona. Go na le what loopholes tse leng gore ne di le teng Parliament le ka go di thiba.
Ari Riane, it's not so much that there were loopholes, at least insofar as I am aware.
Yes.
It was more in response to the public outcry about people being released on bail in spite of having committed some offenses. One of the very topical, over the last couple of years,
yes,
that have been really topical.
Yes.
Especially the khanza murder,
yes,
the polano, the khanza, the violent robbery,
yes,
etc., etc. And the public, out of good and genuine concern, and sometimes out of ignorance, mega motho maabane o na aleha ke no o bolele ngwana ga mmasemang mapodisi ba kile ba motsa ke o togetswe public ga itse ro ga togelo tsatsi la go la tsheko le pele leta. But the public cannot accept the fact that someone is so angry with o tsere maabane ke mapodisi a ba re togelwa after 2 days because agente e tswa go mokopela bail ka mpo makastrata wa mogolotse. Matshwenyego a public ha go roga go ba bosi le ba re direla melao ba re ba tlhophileng ba tshwanetse gore ba supe gore sengwe ba se dira because matshwenyego ga se matshwenyego hela ke matshwenyego a ile gore a genuine. Society is hurting and the lawmakers must appear to have taken heed of the cries of society go dira sengwe. I'll tell you why I'm saying this. Because much as the Bail Act, for example, in
yes,
they are not traditional bail application provisions.
yes,
generally e follow a hela tsone di-principle tsa beile tsone tsele tsa di-case tsa bo Mzwinila bo dipholo boeng tse re tswang kgakala ka tsone. One. So tota, this was more in response to the public outcry. It was a genuine amendment. I think sometimes that Parliament was overstepped, but it's a genuine amendment out of genuine emotion and feelings to believing for the whole protect the public. Jalo. Ke tsone dikgwetho tota tseo tsenele. It's not that criminals were taking advantage of loopholes within the system. No, there were no loopholes. But the crime situation was so high that it merited a response from the lawmakers. And the lawmakers could not afford to be seen to be doing absolutely nothing in the face of schedule, especially when this is a dipolano, tsabomme, le dipolano hela ka kakaretso mo society.
So one mola o mošao ha ile gore gona le diphetogo tseo di dirileng di ha kae?
Ha o ka lemoga one of diphetogo tse leng gore di tla le molao ke go highlight the most fundamental ones.
Yes.
Wa go itlha le gore gona le the offense tse dingwe tse le gore they have been separately scheduled, like the offense tsa bo murder yalo. The offense tsa bo robbery, the violent
armed robberies.
One tsa bo di armed robbery jalo. How ka lebella, which since something the other day I was before another magistrate ke ipotsa gore ame go mo constitutional laws ke batla go checka tsatsi le lengwe la ke bone nako ela ke botse judge mongwe ela re file application re checke the provisions mo ile gore gata ba go twe for this specific offenses like bonobo murder lady robbery, this armed robberies.
Yes.
Marudi a mo go yo latogadiwang ka beili gore a supe gore ke eng a tshwanetse gore a hiwe beili.
Yes.
O bona gore that from a legal purist like me offends the presumption of innocence. So you see, this is why I was talking about about overreach. The burden or the responsibility to justify the taking away of liberty is no longer put upon the prosecution or the state, but now someone must justify why they ought to be free. Which I believe was a legislative overreach. One day is going to get challenged. We will know in time. Maybe I'm wrong, but I think I'm right. We will know in time whether such things they will pass muster.
Yes.
The other thing I could simply give you an example of is the amendment, or the new bail act rather, it's not an amendment,
yes,
is in some ways, I would say, complainant-centric. It's complainant-centric. It really tries to take the complainant along with the process, such that the complainant does not feel like kanya gagwe. It puts obligations on investigators, on prosecutors, to take the complainant along, modilong tse tsotlhe, inform the complainant of trial dates, among others. Make sure ha go na le postponement de go rileng complainant wa tlhalosediwa about, which is a good thing.
yes,
Because I'll tell you something. Ha santse ke le ko pusong ke prosecute. That even in private practice, I did realize, but most of the time, in a haraseka, re the prosecution, really the second court, the high court is there, the whole country. The families of the victims were not there and did not even know. Le ka motho so motho a khwitilwe ga ba itse le gore motho o ne go diragetse eng, le motho a hilwe beile ga ba itse gore ke eng a hilwe bail. You see, those are some, and I think that's a positive attribute.
Yes.
that came with the Bail Act, among others. So, honestly, some really key attributes and positive attributes. Honestly, I wouldn't really say these are changes. Expanded considerations. Tsa gore me ha beile e lebelelwa go lebiwa, I think it's section 5, maybe subsection 7. Mo gongwe go tla bo go listiwa di conditions tse le gore they have to be factored in. Me the overriding principle ya teng ke gore di court di tla lebelela the prejudice, the interest of society, me gape the prejudice that the accused person would suffer by virtue of being denied bail. Considerations of health shall go into the melting pot. The financial losses that this individual may suffer shall go into the melting pot. Yeah. So it's just a codification of principles we've been working with all along.
Yes.
It's nothing new. The real change that I personally see, those presumptions decategorize or provisions that categorize offenses and impose duties on people to free themselves, as opposed to the prosecution justifying why they have to be denied their liberty. Otherwise, they simply codify the common law.
On that last point, the Act is very clear that now the balatuhadiwa, or the accused people, persons, they have to, if they have prior convictions, they have to disclose that. What's your take on that requirement?
That's correct. I think it's fair, quite honestly. I'll tell you why I think it's fair. To disclose does not necessarily mean you are confessing to the crime that's before court. The disclosure is purely for purposes of bail. Yes, there is a catch to it. Traditionally, what has been happening, your previous convictions would only be called up after conviction for purposes of sentencing. Even fingerprinting was not permitted prior to conviction. Why should someone take my biodata before I'm found guilty? Mapodisi ba na le fingerprint tsaka pele ga ke bona molato. You see what I mean?
Yes.
So traditionally, that is how things operated. But the new law says, ha ole hapele ho, o na le obligation ya go bua gore nya me magastrata ha ke le hayana ke setseng kile ka bonwa molato mongwe ko bolebe le ko bolebe le ko bolebe le ko bolebe. Now, these are provisions that are prepared mainly or introduced in to lessen the burden. It's on the prosecution. Those things were not allowed. As a prosecutor, I used previous convictions a lot for purposes of denying people bail. You just ask, please run me this person's name. Because a person's antecedents, in terms of the Mzunila case, are a factor, and I'm talking prior to this act,
yes,
are a factor for purposes of bail. So those things were still allowed, except that the accused person didn't have an obligation to disclose them himself. So the only thing that has changed, ke hala gone gore yaanong go sologela gore motho ene a tare ba gaetso minkile ka bola motho kwa kana ka dira se ha sa bue yalo gore he did not disclose to the court, and then e ka re ka moso prosecution me prosecution ina le di means ko CRB go tlhomamisa di offense tse le gore motho yo, so ke bo tshwakgahela ja puso ke shortcut hela ya gore be go tsewa nnete, but ga go interfere le di right tsa motho at all. That is why ke sa feel gore it's an unjustifiable violation. I think it is fair. If somebody should be asked by a court, Ra, you are here, we are in your bail application. Have you ever been accused of, no, not accused of, have you ever been convicted of any criminal offense before. If he says no, then why can he say That's a legitimate question to ask and to disclose. One. So ha go mo kgoreletse ka sepa gore re hela ka gore go kutla o tukile ita motho ka mpama gore re mo molatong wa le before le khota ka one o wrong.
Gongwe potso e leng gore mongwe o ka ipotsa ke gore mme gone go ke efe melato e leng gore molato ha diwa o tshwantse gore I disclose ke bua yana ka gore le nna ga ntse o bua ke akae bontsi jwa rona we have traffic offenses re di duetse di ticket ka re le bantsi a mme ke mengwe ya those tse leng gore o tshwantse gore o di disclose.
No, what they are talking about is convictions.
Yes.
A traffic offense is not a conviction.
No,
the traffic offense is not a conviction. Yes. That is why a traffic offense does not go to court. How we do it.
Yes.
Yes. These are traffic offenses are quasi-judicial and are dependent on the compliance or the agreement outside court. This is what will happen. In the event that you don't pay the traffic offense, and then it goes to court, what will happen? You will get convicted or acquitted, as the case may be. So next time, do you have a criminal conviction? You're supposed to say, I was convicted, because a conviction proceeds upon a court judgment or ruling. But in case of a traffic offense, the reason why the law has kept traffic offenses out, but in the larger scheme of things, they are not considered to be such offenses. They should put particular disabilities upon people, maybe on account of the fact that most of them, much as didiriwa with intention to harm society. Most of them are based on strict liability, some of them are based on negligence, and most of them are not based on intention at all. Failure to stop signing, failure to indicate, you're not really out to hurt society. It may result in that, but that's not really what you set out to do.
I think lastly, let's look at this one. The Act specifically mentions bailable offenses. There is a mention of murder and treason, and that the accused person in that state pre-committal can't necessarily insist on bail. Justice Moroka, I think, in his judgment, much, called it a traffic light provision. Care to comment on that one?
Yeah, exactly why I said there are instances of overreach, legislative overreach. And ultimately, make no mistake about it, these provisions are going to be challenged in court. And I think it's going to be one of the first provisions to fall.
Yes.
Maloba, was before a magistrate and I spoke of this, and I'm like, Your Worship, no one really tries to see the law that they are putting across through the prism of the Constitution. They are simply trying to placate society or regale the country with a legislative illegality. At some point, it's just a question of time. Some of these provisions are certainly going to fall because there's a legislative overreach, there's constitutional violations. Some of them are going to be ruled as ultra vires the Constitution. So that's why Judge Moroka and Abu Alar, it's a traffic light provision. Traffic light provision. One. Look, it does not matter what the offense is. The presumption of innocence cannot be curtailed by a law made by Parliament. Because the presumption of innocence is rooted in Section 10 of the Constitution. the parent law of all laws. So Parliament can't take away what the Constitution has given. And these laws, ke maiteko a Parlamente to try and undermine that, because mo go bone, there is a legislative failure to deal with the scourge of crime. And they are seeking to deal with the scourge of crime through a constitutional violation. Brings us back to what I've said before. That's why I said some of these laws are written against the state. The state's approach would always be to take the path of least resistance. The state's approach, the state would rather, they would rather, you know what, o guilty, ana maeme ka kwa, o tla tswa a sena go tlhokiwa molato. The Constitution says no. The Constitution is our ultimate protection. So there's always a tension between us as private practitioners and the state to check the excesses of the state. To say, when you do this, you are overreaching. Now, because the state were being hammered in the courts day in and day out, and they had no answers to that. What they then did is they went aside, and then they sat in Parliament and said, you know what, so long as we've legislated it and it has not been declared unconstitutional, the magistrates would have to follow it. Then the magistrates don't have to agree with the defense lawyers. So let's legislate it. Harris now a legislator, the defense lawyers are going to chop at it. After they chop at it and it is struck down, we can say, we did our part. It's the cost that let you down. It's just a trick. Yeah, it is what it is.
No, I understand. I think, let me thank you for joining us today. Ke dumela gore motswana o kgonne go ithuta maka go ithuta a se go bogolo gore bail ga se gore ga bo go letelwa ba ba lato ha ditsweng gore ba itsamaele hela mo strateng. Se se golo ke go that balancing exercise between protecting the public and personal liberty. That is
which is true. And I might remark on this, Happy.
Yes.
You see, problem where bail prosecutorial inefficiency.
Yes.
Sometimes this is not a bail case. If the prosecutor was really trained, especially also because some of these bail applications they are not trained prosecutors. They learned on the go. Some of them have become very good, but many of them could do with a bit more training. So the state has not invested in them in terms of training them for purposes of bail applications. And sometimes even the professionals, they don't have the experience to deal with bail applications because it is a body of law that requires focused training. And so long, if the prosecutors are not up to scratch and have not been trained to deal effectively, especially at the police level, you will continue to see someone being arrested today and released tomorrow. So quite often, we run to the law to say we are fixing the law. No, sometimes the legislature didn't even need to go to fix the law. They just needed to train the prosecutors with the tools that are already available, get stakeholders meetings, get defense counsel on board, because you are all stakeholders in this justice equation, see where the loopholes are in terms of training. We would be more than willing to help them.
Yeah, true.
Because we are not on the side of crime, we are on the side of the Constitution. If right now we have to go to drill them on how to make a defense, mapodisi, to a bail application, they would find many lawyers, babamo private practicing, willing to do that. Now this wrongful thinking, hey, prosecution, enemy, and all those, that's an impairment to progress.
Yeah, no, the reason I'm laughing, Council, is there was time I was stopped at a traffic light. And then as he's writing the ticket, he learns I'm a lawyer. He's like, hey, kana lona le ba ba rutelwang go ntsha magodi mo toronto.
Sure, my brother.
So,
thank you very much.
Thank
you, man.
Until next time, thank you for watching. Have a good one.